Kwadwo Poku.
Something, I beg you give me a bit more time to do two things. I already had my thoughts on the legal issues, which Attorney General, based on filing a nolle prosequi. I wanted to comment on that. But there's this topic that keeps coming up, and I want to really address it today, since this is one of the most authoritative shows in the country, which is why we have spent, people keep saying that why did we spend 30 billion to collapse banks that we could have spent 8 billion? Let me really put that to rest today. Please help me. Look, banks, before they are collapsed, which the Bank of Ghana withdraw its license, have to be insolvent. So there is an insolvency, meaning that the bank is not fit for purpose. So it's not government. There are two institutions here. There's government and there's Bank of Ghana. All the banks prior to 2018, in 2016, the Bank of Ghana did what is called an asset quality review, which is to check your non-performing loans as a portfolio, check your asset ratios, your insolvency ratio, and all the ratios that there is. Then there are benchmarks with which you hold your license. You fall below that benchmark, Bank of Ghana will prompt you that, look, bring your insolvency to the benchmarks that is required for you to have your license. Unibank, as far back as 2014, was below those ratios. So it was getting what you call a liquidity support from the Bank of Ghana.
Just like the others.
Yes. But I just want to stick to Unibank for a minute. They got as much as 2.2 billion Ghana cedis from the Bank of Ghana as liquidity support. They were asked to stop their massive expansions that they were doing. They were asked to stop a lot of things that they were doing. They did not listen. They still went ahead and do those things. Apart from government contract, they went into real estate. They went into form all the multimedias and all the things they did, right? So the bank, as all those banks that were collapsed, were insolvent. So it means that they were not fit for their license. When that happens, bear in mind, as of 2017, Unibank had an asset of 5.9 billion, right? Then it had a loan portfolio which was bigger than depositors' money. So the loan portfolio they had at the time, loan and advances, was 3.2 billion. Depositors' money was 2 billion. In that case, it means that people's money are in these banks. Now, if the bank collapses, guess what? Everybody loses their money because the bank is collapsed. So these banks collapsed, not because of anybody. They did not. The mismanagement of the bank has caused the bank to be insolvent, so Bank of Ghana withdrew their license.
Yeah, but there's a difference in expert opinion. One opinion says pump as much as over 30 billion to clean up. Another opinion says you can spend less than 9 billion to rather keep them afloat. Let me get there.
Government doesn't come in. This is a purely Bank of Ghana exercise. Government of Ghana has no business bailing any bank. The banks are private institutions. They do not meet their requirement for their license. The Bank of Ghana withdraws that license. Where the government comes in is governments responsible for depositors. What the Danado government did was borrowed money to pay depositors who have lost their money, not to put it in the bank to save a private bank. It's two different things. So if a private bank fails, the citizens have their money in these banks. They've lost it. Kwadwo Poku have said on many platforms that I wouldn't have borrowed that money to pay back depositors' money, because most of the depositors who today are saying ill things about that action got their money back. Most of these depositors, that 30 billion we are saying, went to Ghanaians.
You now want to proceed to...
Now, let's put that to rest, because that 30 billion went to Ghanaians. As long as
we all have issues with.
Well, you can have issues with, but the fact of the matter is that that 30 billion went to Ghanaians. Now let me go into the legality of that.
But I need you to know. I need you to note something which I have mentioned before.
Okay.
Of the 420 financial institutions that, according to the Banks and Special Deposit Taking Act, they will have to be affected because of insolvency. There is proof that some were not actually insolvent. There's a matter which is live in court now. I won't talk about it. The Bank of Ghana led them to use their own funds to pay off all depositors and left balance in their accounts for the shareholders and everybody. That shows an institution that was not insolvent.
That's a Bank of Ghana issue.
You wanted to make a small point.
Yes,
Make it quickly.
I just wanted to say that as a government, you have a responsibility to the financial system, first and foremost. So if a bank is insolvent, and you think that by the central, and there's no way the central bank will take that decision without consulting the central government. If you get that consultation, and you are aware, for instance, the Bundesbank or one of the German banks will go there for loan these days. It was a private bank that was struggling. The government of the day didn't collapse it. You could simply say, look, shareholders, we want to come in and support you and save the financial system. Can we agree a system that allows us to get involved as shareholders? Put the part of this 30 billion as shareholders, work with you to turn around the bank and have an exit strategy to give it back to you.
Which is exactly what we did.
Exactly.
Which is CBG.
What you did. So what you do is not to spend 30 billion to pay depositors.
No, but what I'm saying
now, you must also understand that the government's own banks were insolvent. NIB was insolvent, had negative net worth. Was it collapsed? Because government consulted the central bank and agreed to exercise regulatory forbearance. It has kept it for all these years. How did the government...
ADB has some problems.
Exactly.
Okay, so please.
So it is not true to say that because it's a central bank, it's owned by the private person.
Thank you, Adoma.
You can't get involved.
Part of that money was what gave birth to CBG.
Right.
Because when CBG was formed, bear in mind, when you put bad banks together, they don't become a good bank. You put bad banks together, they still have the problem. So government now intervened by pumping money into that company for them to raise new capital. So that happened in CBG. So let's move on. Now,
Are you in support of this decision?
No, not at all.
To take 60% and
not at all. And that is where I'm not a lawyer, but I speak to lawyers a lot. And with my little common sense, I wanted to understand a few things. There is a procedural problem for me. When somebody is charged with a crime, he goes to court and he pleads guilty or not guilty. In this case, the 7, including Mr. Dufo, pleaded not guilty. If they pleaded not guilty, they have to now prove their case in court, and the judge will decide whether they are guilty or not.
That's right.
At what point did the AG start negotiating with them? If somebody has pleaded not guilty in court, where is there a negotiation? The other avenue for me is that when you plead...
Let me suggest that to you.
Okay.
So in our everyday practice, and I do this too many times, where I let my clients plead not guilty, even though you may think that they should be pleading guilty. But their first appearance, you let them plead not guilty. Then you begin to negotiate behind closed doors.
Okay.
Then if the negotiation works, you go back and change your plea.
Thank you.
And you can change it to a plea of guilty and then get a plea bargain and get away.
Thank you. So in that case, the only time you can now plead guilty and then a plea bargaining comes in, and that plea bargain is presented to court as a way to ending the case. Did it happen in this case?
We are not aware of it.
It did not, because the man went to court. He's found not... Because bear in mind, the money retrieval is part of sentencing, because forfeiture is part of sentencing. When you are sentenced, your recovery of the money is part of sentencing. In another jurisdiction, you are given 5 years plus a forfeiture trial. So when you do not recover a certain amount that the court sets, you are now asked to come back and they will add to it. So let's say you are given 5 years and a forfeiture of, let's say, 60% or 80% of the money that you've gotten through ill-gotten gains. Then if you do not recover that money, at the end of your tenure, of your sentencing, you go back to court and the court says, yes, in failure to bring back the 80%, do another 4 years. So forfeiture, which is the recovery of the money, is part of sentencing. What we should remember, and I like what other people have said, that we are now creating an avenue for loot. Because when people realize that you can take enough, do anything that you want to do, and the NDC for me is sad because, bear in mind, they promise us that they are going to protect our public purse. In protecting the public purse, the Minister of Finance, and I like when you read that thing to Professor Abuchi, is that 2.2. They are saying that they don't want to continue because what? They don't want to now go, my brother has repeated it, chase after whatever. Somebody is doing 15 years today, right? How much was her crime? 15 years. So what the state is supposed to go after is the indictment, is the punishment. Forget the money, because a crime has been committed. And as my brother rightfully said, if you now plead not guilty, then prove your case. But if your lawyers negotiate and you want to refund, then there should be an indictment, because you can't have it both ways. You can't have a no indictment, because now, as we speak,
what they have done
yes,
is to file a nolli prosequi, which is a power given to Attorney General
yes,
or the state to, at any time within the trial, decide to stop it.
yes, so that the person goes away with the money.
Yeah, you don't need any excuse. And Professor Bochi was trying to explain something. We have two of them. We have what we call withdrawal, and we have a nolli prosequi. When the withdrawal is filed after the prosecution have closed their case, there is an acquittal and discharge. The case cannot be revisited anymore. You understand?
Yes.
In this case, he's explaining to you that this is a nolli prosequi, and nolli prosequi does not amount to acquittal. It only amounts to a discharge. So they have said, financial prudence. We don't want to waste more
But
money.
it's not for them. You see, I like the bit where Professor Bochi comes in and says there's a discretion and the Constitution gives discretion and all that. But it's a state's money. I mean, I really don't think that somebody appointed an Attorney General today, 2.2, Attorney General is in court, is in many courts. And rightfully, all the lawyers have said that you give a nolli prosequi, you don't give explanation. Case ends there, because they've done it in several cases, right? There are many nolli prosequi that no explanation was given. Everybody will speculate and say whatever. But this case, you've opened yourself to the conversation.
It's progressive jurisprudence.
Well, that's fine. But the point,
there's public interest. So if you file a nolli prosequi, explain.
But the point is that what explanation you are given that you think that you do not want to now chase after that because it is not worth. Attorney General across the country, the state attorneys are in court for 100 cedis, 20 cedis, 50 cedis, people who have stolen goods. They are being prosecuted.
That's right.
So why are you telling me that 2.2 billion is what? Is you don't have enough money to go after 2.2 billion? That is where the state is looking. And especially from a government who told us that they are going to protect our public purse. I think I'll leave it there.
And they are